Hi, good afternoon to all of you. Before we can start the day, can I confirm whether you can hear me? Thank you, Kwan. Right, Karen, thank you. Karen, you were not here today, if I'm not mistaken. Perhaps your work or something else. Okay, just to confirm that because maybe I overlooked your presence yesterday. Anyway, we are looking at today's perspective, okay, on the revision series. And before that, I have a question. I received a question here, all right, direct message. Just two short questions from yesterday's lecture for those students whom consider answering a privacy essay question. Do you have any suggestions for preparations? Okay, my suggestion is, okay, I am looking at there is a high possibility of a problem question, okay, on privacy law. Is just a guess, but I'm substantiating with the reason why, because after the compulsory article, given 2 years back, 3 years back, then the following year, okay, students were tested on a full-fledged essay question, full-fledged essay question on all aspects. And then in the following year, okay, students were tested on the specific areas like criminal issues or other children, okay, and also royalties and commercial interests. So now, for the past 2 years, students already had this, have had this flair of revising the entire privacy law. So what I believe is, okay, this year, the examiners may create a question, problem-based question on privacy law to see whether students are able to use whatever laws that they've learned to apply to the facts in issue. Okay, so that is my opinion, but that's what I also expect that the examiners may do instead of continuing to ask essay questions. And then for problem question yesterday, when a person blocks the other from free movement. This is the second question. For the problem question yesterday, when a person blocks the other from free movement, just a minute, a bit of interruption on my WhatsApp web. Let me close the file. Can he be charged with harassment act protection? Can he be sued? Not charged. Charged is more of a criminal issue, but here tort law civil liability. So can he be sued with harassment and therefore in violation of Protection from Harassment Act 1997? Okay. Now, it depends. Okay, mere blocking of another without lawful authority, okay, will avail for trespass to the person under false imprisonment. But to be able to sue for harassment, you must satisfy the criteria under Section 1 and Section 7 of Protection from Harassment Act. Let me highlight to you that again. Let me go to privacy law and show it to you. Sorry, not privacy law, trespass to the person. Is it sorry, it should be privacy. Right, I've opened the file already. Let's analyze the law proper in this area. Okay, sharing screen. Right. So the description of harassment, okay, in Section 1 is somewhat circular. It has been deliberately defined broadly and clearly goes beyond the mere stalking. It's not stalking, not about stalking alone, which was the principal target of the act. So the general feeling that Thomas, under Thomas National News Group newspapers, harassment is a word. This is a normal way of looking at the general perspective. A word which has a meaning that is generally understood. And what is generally understood is defined as conduct which includes alarming the person or causing the person distress. So if when you block someone, and if the other person subjectively can show proof, all right, and on the facts of the case, the court is able to objectively feel based on the evidence that the other person, right, suffering from some kind of a distress, then there is a possibility for you to sue the person under Protection of Harassment Act. And the course of conduct is stated involve conduct at least, okay, on at least two occasions. At least two occasions, not once. If it is once, okay, then it might not be a harassment. Okay. And may include, right, speech also. Although the new cases now give some guidance, okay, as what Baroness have stated, a great deal is left to the wisdom of the courts to draw sensible lines between the ordinary banter badinage of life and genuinely offensive and unacceptable behavior. It's very much related upon how the courts are analyzing the facts, okay, in issue. Okay, let's take one example, Ferguson British Gas, where the persistent sending of unjustified bills are that amounting to an harassment. So, coming back to your question, if we were to interpret the law in itself and looking into the situation where the person is being blocked, okay, there is always a concern as to whether harassment would have taken place or not. And that again, this is only one occasion. So that may defeat the line of harassment. Number two, all right, was there any form of distress, okay, occurred on the part of the claimant? Okay, and will there be a distress in that kind of a situation? If there is so, then there is again possibility, but there must be two occasions, right? Whether it's similar occasion or different type of occasion, but there must be two occasion, minimum two occasion, because like continuous phone calls, like Khorasanjian and Bush case, right? Silent calls, every time calling, that has caused some form of distress to the claimant, that has caused an issue of harassment already. Okay, as a result, the statute came about, Protection from Harassment Act 1997. But in tort law, when you see the facts, you don't see any indication from the examiner, then do not cite. You do not, you can't imagine. That's all. Okay, what was stated, we work based on that. But it's no harm in raising the PHA 1997. No harm raising it, but you can dismiss it straight away. Right? I hope I've made it clear for you, Henry. Thank you. Okay, let's move on today. The rest of the thing, yesterday's one, I leave it for you to continue to read because it's a matter of continuation of what you need to read. But if you have any further issues, feel free to email me, right? So that I will be of assistance to you by replying with authorities, Not just a brief reply, but I will reply with authority so that you are you have sufficient cogent information to submit in the event that those things are tested in the examination. Today, we are looking at one other popular topic, the tort of private nuisance, public nuisance, and the rule in Rylance and Fletcher. This topic is crucial, okay, for you to know in all aspects of nuisance if it is an essay question. If it is a problem question, there again, okay, you need to understand that it's not going to be focused on one topic. It may be, you may be tested on the different parts of nuisance together with Rylance and Fletcher and possibly negligence. So that's what we need to take note of. And if you are looking into the gravity or frequency that the students are being tested on this topic, okay, I would say high. Almost in all exam papers, you will see a question on nuisance. The significant area that usually the examiner will pose to you, okay, no longer like a question where substantially you need to answer on private nuisance, and no public nuisance can be small area or violence and pleasure. I think based on the recent trend, okay, the examiners are trying to leverage it. Okay, leverage in the sense that you may need to give equal gravity. Okay, maybe like, 3 areas to tackle means 40, 30, 30%. Okay. 4 areas means maybe, 40, 30, 20, and 20. Those kind of a gravity. Of course, private nuisance will be the utmost important area for you to master, right? And let me share some of the materials to you. I can't remember whether I've dealt this topic with you or not, but just to run through quickly on the notes proper, okay, notes proper on nuisance. I'm going to upload it in your chat, and eventually later I will still be submitting it via email, via email. So let me get the topics here. Thought of nuisance, and I'm going to share the presentation slides of the topics. Thought of private nuisance. Number 2, the rule in Rylance and Fletcher. Just in case you don't have these, if you have, that's fine. But if you have a different set of notes, doesn't matter. You can use that together with this. The rule in Rylance and Fletcher. In lecture notes, given already. Thirdly, for today's revision workshop, you can use this already. I have added more information for discussion purposes. I'm so sorry, wait, let me check. Have I? Okay, I'm supposed to share it to everyone. Okay. The next document is nuisance, the rule in Rylance and Fletcher. Okay, the next one is if you have the time, most likely we're going to run through quickly on the public bodies. Okay. Okay, I've uploaded them. Let's have a quick run through on the first topic. So I'm sharing screen now. Okay, a quick run through on the law. There are 3 types, basically public, private, and statutory, but our concentration should be based on the syllabus on public and private nuisance. And public nuisance, there are some notable authorities such as AGPYA quarries defining what is nuisance, public nuisance all about. And then when we talk about public nuisance, the damage must be substantial rather than consequential, right? And direct, it must be direct. Substantial basically mean you must suffer a special damage. So we have cases like Castle against St. Augustine Links. We have Bolton and Stone, Miller and Jackson is also another case we can cite, together with Tate and Lyle Industries against GLC. These are the 4, I would say, notable cases. So in the examination question, okay, so examiners may give you a what we call guideline by highlighting 1 case or 2 cases, but that doesn't mean that you do not use other cases. Those are what you call relevant cases for the question, relevant for the question. But in answering the exam, you need to add 2 other cases. All right, every question will have a different gravity, different focus. So those cases are quite particular to that particular question. But that doesn't mean that you answer exam question based on those cases given to you by the examiners. You will still need to highlight other relevant cases, but might not have significant impact, just to satisfy the structure or requirement of the law in itself. So here we have 4 cases on public nuisance. When we talk about private nuisance, they are protein, so it depended upon the categories of private nuisance that we are talking about. Usually there are 3 categories. I wouldn't know whether you've gone through this or not, but just to heads up on this point, okay, there are 3 categories of private nuisance, 3 categories. And this was identified by the House of Lords in, or rather instated because it was not structured and highlighted in one document or rather one judgment, but it has been understood to be from various case laws. But in Hunter and Canary Wharf, Hunter against Canary Wharf, the House of Lords, okay, identified that there are 3 categories of nuisance. Number 1, okay, direct or rather direct physical damage. Direct physical damage. And if you want to know the example of direct physical damage is basically like cricket ball, in the case of Miller and Jackson, where they hit it out of the ground and then went and hit the window pane of the Miller's house and then broke the window pane. So that's an example of direct physical damage. It can be also negligence, but it can also be discussed under private nuisance. That is 1. Number 2 is encroachment. So when we say encroachment, how do we identify that there can be a nuisance by encroachment? It's a type where you can see it from the facts where there is a branch of a tree overhanging to the neighbor's house, or rather the roots of a tree, okay, would have been, okay, what you call grown to the neighbor's land already. So these are the situation where you can rightfully sue the defendant under the tort of private nuisance. But the third one is the most popular one, where it has a form of an interference. Interference with quiet, peace, and enjoyment of life of a person. Quiet, peace, and enjoyment of life of a person. So when I say interference with a quiet, peace, and enjoyment, we are referring to various type of interference, such as noise, dust, what we call this, other than noise, the smell, those are the things that you can actually look forward into. Okay, so this is the third one, which is the most popular one. Let me erase what I've written here. In order for you to establish, okay, private nuisance against the defendant, the first step that you need to ensure that you have the right. The plaintiff, or rather the claimant today, must have a right to sue. And right to sue will only be available if you have an interest in the land. Remember, nuisance, Rylands, and Fletcher, and also trespass to land, these are the torts where you can only sue if there is a physical damage or interference, for example, in nuisance. But you cannot be successful under if you're suffering from a personal injury. If you are suffering from a personal injury, you cannot sue under nuisance because these torts are related to land. This was, okay, strongly reaffirmed by the House of Lords, again, in the case of Hunter and Canary Wharf. You can take it down what I said. So only for, okay, physical damage, not for personal injury. So as a plaintiff or the claimant, you must have an interest in the land. If you do not have an interest in the land, you can't sue under private nuisance. An interest in the land can be a proprietary interest, or you can also be a tenant of a land. Okay, so you can either tenant or owner. Can landlord sue? Usually no, because you must be an occupier. You must be an occupier of the land. Okay, you I'm sorry, the internet system was down. But in the event that it recurs, then I will switch to another device, right? Just to ensure that the class is not interrupted too often. Okay, going back to what we have discussed just now. That is on the part of the claimant. Then you are also required to identify whether you are suing the defendant rightfully or not. Is that the correct defendant? So defendant can be anyone so long that they are occupying the land, or they can be a landlord, they can be a creator, doesn't matter, right? So you can actually sue them, because so long that your land is affected, okay, then you can actually sue them, right? Landlords, yes, of course. But when it comes to landlord, they are not occupying the land, so they are not causing the harm. Usually, the person who's causing the harm is maybe the contractor or other the tenants or so. So we need to see whether the landlord has authorized it or not. The landlord knows that the occupier or the contractor is creating a lot of noise. If the landlords have authorized the nuisance, then landlord can be the rightful defendant. Okay. Now, when it comes to occupier, yes, definitely occupier can be sued, and best authority you can use is Sedley Danfield against O'Callaghan. So you need to satisfy number one, claimant and the defendant, and you must also identify, okay, the nuisance that is at stake. This is for private nuisance. Public nuisance, you don't have to prove the locus standi. You don't have to show that the claimant has an interest in the land. Not necessary. For example, Bolton and Stone. The lady was walking outside the cricket ground. She doesn't own the land, but she can still sue under the tort of nuisance, or other public nuisance we call. Okay, having said that, moving to next part, the requirement. The main requirement is very simple. Okay, the main requirement will be very simple. Okay, they are where the plaintiff who has caused an interference, and the interference that has been caused can be argued to be unreasonable or unlawful. Okay, unreasonable or unlawful. Adding to that, I add here, just adding to that, the second part that you must prove is the test of reasonable foreseeability. Okay, as can be seen from the case of the Wagon Mound. Wagon Mound, number 2, affirmed by the House of Lords in the case of Delaware and see what I'm typing. Let me bring it down better. Easier. Delaware, mention against Westminster. Very straightforward requirement. No need to worry so much about this particular requirement. The first, this requirement is very important. This is very important. Okay, the test of reasonably possibility is not that controversial, okay, under the tort of private nuisance. Okay, so long that you can highlight the concept of reasonable foreseeability, right, based on what you learn under the tort of negligence, that will be good enough already. Okay, right. So what is very crucial for us to highlight and making sure that the defendant is responsible is by showing that the interference is unreasonable. So how do you determine that? There are factors to consider. For example, factors like the purpose, his purpose. So malice is one of them, one of the factors that always to be considered by the court, whether malice is involved or not. If there is a malice, then chances very likely that the defendant can has the bad purpose, bad intention, so nuisance can be committed. right? So Hollywood Silver Fox Farm Limited against Emmet is a good case to cite. Adding to that, you can also refer to other cases like Andrea and Selfridge and also Bradford Corporation against Pickle. But Bradford Corporation is important because the court held that malice is one of the factors to be considered. Ordinary use of land is usually cited as a general criteria. Okay, Baron Branwell highlighted in Bamford and Turnley. I'm going to highlight to you during the workshop just now. I mean, on the past year question, I'll highlight it to you again. Other than that, students must also understand, okay, about the duration. So the longer the duration or the longer the time that they are causing the harm, then it is highly likely that nuisance is committed. So this factor is very important because we talk about the duration of harm. Right? It's a very important factor. Like, for example, you are doing the piling work or construction work day and night, or always at night. Then that has affected people around who wanted to have a quiet peace and enjoyment of life, as in the case of DK's Royal Hotel against Spices Brothers. Okay. However, if you are causing harm, but you are doing it in a very limited time, like reasonable time of a day, then nuisance may not have been committed, even though it's affecting people. Harrison against Southwark. These are the two good cases to compare about the duration. One is construction work during the reasonable time of the day. And in D. Kaiser's Royal Hotel was construction works done in the middle of the night that has caused harm to the neighborhood. Okay. And at the same time, we must also understand the character of the harm, the nature. What is the harm that is caused? Is it a smell? What smell is it? Is it a noise? What type of noise is that? Is the noise tolerable or intolerable? Is the smell tolerable or intolerable within the general observation in the context of the neighborhood? For example, all right, chilies, all right, smell of chilies. I don't know whether smell of chilies is tolerable within the society in Hong Kong, but in Malaysia, in a way, people are tolerable to chilies, chili powders and so forth. In India, it's tolerable, but not in England, because it's not a kind of a spice that people use always. So it's a very unique, what we call ingredient, where commonly used in India, or rather where the society is full of Indian community, where chili spices are very common to be used. Durian, second example, in Hong Kong and China, durian is not something abnormal. But in Australia, okay, the smell of durian can cause a high sensitivity within the society, and they may suffer interference. Okay, so it depends. So we have important case for you to cite. Generally, you say that the court will, right, look at, okay, all the circumstances of the case to decide, including the background of the facts, including the locality and so forth. But one important thing that you need to know, which I'm going to highlight to you later, is the cases of, will be the cases of Robinson and Kilworth, and also the case of McKinnon against Walker. These are the two important cases that you must use in the examination for you to compare whether this is a normal sensitivity or abnormal sensitivity. Okay, normal sensitivity or abnormal sensitivity. Let's say everyone can smell durian, that's fine, but you are not. Then it's abnormal because you are not within the right societal condition where everyone can accept. So it's abnormal sensitivity. Then the court might be a bit more reluctant to allow nuisance claim, right? So Robinson and also McKinnon. Then the locality part played a very important role in nuisance, because we must always see what kind of locality is this. Traditionally, we looked into localities such as whether it's a commercial area or residential area, okay? And the highlighting case will be the case of Sturgis and Bridgman. Very, very, very important case, right? For you to cite in the examination, Sturgis and Bridgman, because it stood for a couple of propositions. Number one, the locality. And what Justice Thasaja said in that case also very important. Justice Thasaja is in your revision notes, don't worry, where his lordship brought in a very famous quote. What can be a nuisance in Belgravia Square may not necessarily so in Belmonte. Right? Different part of property, same kind of interference, but one can be a nuisance, the other one may not be a nuisance. I will also eventually come up with an update, very important update, okay, very important decision made by the Supreme Court, okay, in a very famous case of what do you call this, about the gallery, overlooking through the gallery. I'm going to come back to you. It's a landmark decision made quite recently that has brought upon a question as to whether can Hunter be revised eventually or not in the near future. Okay, that is later, but let's understand the structure proper in brief. Defenses, if you are talking about defenses, coming to nuisance is a type of defense will always be raised by the defendants. However, over the years up until today, this particular defense is not a defense or not a good defense. It's not a defense at all. You raise, yeah, but the court will not accept. Even though we have a bit of a dissenting judgment made by Lord Danning that should he had actually highlighted this that it can be a good defense, but up until now, no highest court of the land has affirmed, okay, his dissenting judgment. Okay, let's see in future maybe. Number two, you can't argue, the defendant cannot argue that usefulness is a good defense. No. All right, cricket ball, usefulness, no. I'm supplying water, useful, no. It's not a good defense. Again, nuisance due to many, defendant cannot argue. Other people not complaining, only plaintiff is complaining. Is that a good defense? The court say no. The fact that plaintiff is suing, that is his prerogative. He is affected. He is suing you. Other people not suing is none of your business. I am suing you, you defend me. That's what the observation all about. So nuisance due to many is not a good defense. The good defenses are prescription. Okay, as I highlighted in the case of Sturgis and Richmond again, prescription, this is a good defense where nuisance already been committed for 20 years and the 20 years set in already, you can't sue after that. You didn't sue, you must sue within 20 years of nuisance created. Yeah. Statutory authority is another good defense because when statute authorizes of you doing certain or running certain things or other doing certain projects, and if at all it causes nuisance to residential or residents or people nearby, and the defendant will have a good defense by raising statutory authority. Statute give me authority to do, but statute must give, not permission given by the local authority. It must be a statute. So if local authority giving you a permission to run certain thing, and let's say surrounding people suing you, and you are saying that I got a permission from local authority, I cannot be sued. No, that's not how it works because that is not given by parliament. It's just that planning permission means for you to do something else where the landscape has been changed or activity in that area has been changed, then the local authority wanted to change the what we call the availability of the type of business you're doing. For example, all right, this particular property always been used as residential property, but over the years or decades, the property has been grown, modernization taken place, and people cannot really stay there, but rather they use the buildings for business purposes. So local authority must give the permission for you to run businesses in this area already. So that's called planning permission. So that is not a defense that you can be successful. Yeah, Coventry and Lawrence. Coventry and Lawrence. Another important House of Lords Supreme Court decision where you need to take concern two things from this case. Number one is the defense of planning permission. Number two is the claim of injunction. These are two things that Coventry play a very important role, right? Injunction, as I said, Coventry is important. I need to highlight here also Coventry's case. Let me highlight it here. All right. It's Lawrence. Why it is important? Because In Coventry and Lauren, the court held that shelfer cannot be used too technically. All right. Shelfer cannot be used too technically. The courts will have a discretion in its own account rather than going through the requirement laid down in shelfer. Requirement in shelfer should not use, okay, too mechanically. Even if the shelfer's requirement is useful, but the court can still decide on its own accord whether injunction is available or not. Shelfer said if the damage of the claimant is small, then compensation must be granted. You cannot apply injunction, but Coventry said no. Injunction can still be made, no matter whether your losses are trivial or not, doesn't matter. So that is the distinction that has been made, okay, in the case of Coventry against Lawrence, okay. And this can also be seen but was not authoritatively mentioned in the case of Canaway against Thompson. So these are the two good cases together with Shelfer when we talk about injunction. Miller injunction, right, is where the court refused injunction. An example where the courts refuse injunction because playing cricket is in the national public interest of the United Kingdom. Football, cricket, they are, all right, quite a prominent sports, okay, for the UK people. So even the government endorsed those kind of a game as a very desirable sports, okay? Right, having said that, damages, yes, you can be awarded with damages so long that it's foreseeable, Wigan Mount, okay? Abatement is a small issue, like, you're asking the other person to remove, okay, whatever nuisance that he has created or stop making noise. Those are called self-help. Self-help. This is a very minor thing that we are observing when it comes to remedies. Okay, abatement. Having said that, I hope the reflection is there already to understand nuisance. There are other authorities, if you have, you can use, no problem. There's no exhaustion to that. However, important thing is how you approach the question and answer them. That is important. Let's look into the past year question. Let me close the file. Anybody came in new so that I need to attach the notes. Everyone received, huh? Right. Okay, as usual, the caution not to use too mechanically on my outline, but it will be of some help to you. We are looking at the most recent question last year, 2023 Zone A, and also Zone B, both, and both students were tested on problem questions. So I'm not going to go into all the questions, the downwards. I will be selecting some of the questions only that are relevant for discussion to cover within the time frame that we have. So let's start off with problem question 2023 Zone A. Question A. Cold Spring Water have operated a sewage management service in the village of Longfield for 2 decades, 20 years. 2 decades, 20 years. Fred and Gladys have lived in Fir Tree Cottage on the edge of the village for 35 years. Okay, right. So they've been living there for longer. But our friend Cold Spring Water, okay, operated a sewerage management service for 20 years. 20 years mean when it mentioned in the last 3 years, we are referring to 17th year, in the last 3 years, Cold Springs sewers have begun to overflow into the properties in Longfield. So when it overflows, definitely it is going to cause a lot of uneasiness, smell especially, okay? Every spring and autumn, okay? When we say spring and autumn, autumn, winter, spring, and summer. So there is a gap, 4 months, autumn, 4 months, winter, 3 months, autumn, 3 months, winter, nothing happening winter. 3 months spring, then there is another problem. So there's a gap, 3 months gap, and 3 months, spring and autumn. So the foul-smelling water has destroyed many of Fred's valuable rose bushes. Physical damage here. And at times, the couple find it impossible to sit in the garden. Why? Because of the smell. Many of the residents in their neighborhood have begun to develop physical symptoms. Many of the residents. Then this brings us to understand that this could have been a public nuisance already, right? Now, Martina is the live-in nanny for the children of the Scott family who live next door to Fred and Gladys. She believes that her migraine headaches are aggravated by exposure to the sewage water. Now, before we look into the main relevant issues in this question, let's analyze progressively. The first step, what we must do, we must see whether this is a private nuisance or public nuisance area. Okay. For example, we are looking into first issue, that is overflow into the property. Okay, sewers have begun to overflow into the properties. So it may be a public nuisance, may also be a private nuisance, but most notably, you can see that it is actually water or sewers that has been brought into the land and escaped. So it looks like this could have been an issue of Rylance and Fletcher. This could have been an issue of Rylance and Fletcher. And then you have this foul-smelling water destroyed. Okay, foul-smelling water destroyed many of Fred's valuable rose bushes. Okay, so the smell. So this can be rightfully argued under the tort of private nuisance. Thirdly, many residents in the neighborhood have begun to develop physical symptoms. We call it as a special damage, substantial enough physical symptoms. And many of the residents, class of the majesties of the subject, okay, which shows that this could have been a public nuisance. Finally, Martina, live-in nanny who live next door. She believes her migraine headaches are aggravated by the exposure of the sewage water. Migraine headache is not a physical damage. Migraine headache is not so much so on the quiet peace and enjoyment of life. Rather, migraine headache is a personal injury. So one such problem that Martina may have is arguing under nuisance because of the personal damage. Personal injury. Okay, so more or less you can figure it out. Then the next step, what you need to do is find out whether all these claimants have the right to sue the defendant, because we know for the fact that defendant is occupying the land, so no issues about the defendant here. Cold spring water. We need to understand who are the claimants. Fred and Gladys have lived. Fred and Gladys. So we don't know whether they are husband and wife, was not mentioned here. But there are two parties here. They are living there. Do they have the interest to sue? So they must have an interest to sue. And fair enough, because the examiner more or less did not mention clearly, but we can understand they have lived for 20 years. They should have either tenantable interest or other proprietary interest. So they have the right to sue as a claimant here. Then many of the residents, yes, substantially, outsiders can sue also. Martina, we have a problem here because she is a live-in nanny. Live-in nanny means she has a license to stay. She is not a tenant. She's not the owner. So she may fail under nuisance again. So if that is to be the case, we can dismiss nuisance for Martina, but chances are Martina may well be suing the defendant under negligence. See how they mix the issue. Rylance and Fletcher is there. Private nuisance is there. Public nuisance is there. Negligence is there. Are we clear? Okay, general remarks. This popular problem question raises standard issues of nuisance, public-private, violence, and also possible negligence. Nuisance problem questions almost always include these four aspects, and candidates are made aware of the importance of considering them. Every question always consider these four aspects because nuisance must always be compared with negligence. So private nuisance, public nuisance, violence and fletcher, and negligence. Okay. These are the some of the notable authorities for this question, besides what I have mentioned earlier, the structured authorities. Yeah. Okay, so the courts apply a rule of give and take. This was highlighted by Baron Bramwell in the case of Bamford and Turnley, 1860. Live and let live. There must always be a give and take principle. As much as you are being interfered in some way or another, but the owner of the land must be given the opportunity to enjoy his land without any disturbance. Right? He would like to make noise, let him make noise. He would like to do some construction work in his land, let him do. Give and take. Understand his position also. That's what Bramwell said. Okay? Do not be too sensitive. Live and let live. Then only there can be a harmonious relationship between neighbors. That was the orthodox way of highlighting the importance of neighborhood by Bramwell. Okay? But there must be a balance. There must be a balance of convenience and inconvenience as between the competing interests, competing rights, and interests of the two parties to the action. This was highlighted by Lord Blackburn, right, in 1881 in the case of Dalton against Henry Angus. So in the examination, upon establishing the criteria of nuisance there, upon showing what type of nuisance is there, upon proving that the claimant has a right or not, then our next step is to highlight, okay, when you talk about private nuisance, right, this is going to be the point. I'm highlighting on a private nuisance here. Okay, the relevant authority is for the private nuisance here. Bamford and Turnley. And as I mentioned, Malone and Lasky, yes, it's about interest in the land. Only claimants with an interest in the land or exclusive possession could bring an action for nuisance, right? And Lord Gough mentioned that on the authorities as they stand, an action in private nuisance will only lie at the suit of a person who has the right in the land. And this was the version in Hunter against Canary Wharf. Okay, Hunter against Canary Wharf. Okay, I think a bit of a, yeah, I highlight Hunter here so that you're aware. Okay, so question now, the House of Lords asked in Hunter and Canary Wharf, did an actionable nuisance exist or not? Did an actionable nuisance exist? We need to see the criteria of the nuisance, the elements that we need to argue. What is it? Noise, smell, dust, whatever. So we need to ask ourselves this question. Likewise, in the case of Hunter and Canary Wharf, what happened? The House of Lords held that interference with television reception by the erection of a building did not amount to an actionable nuisance. That means the Supreme Court, or rather the House of Lords, could not create a new precedent that interference with television reception amounting to a nuisance. Issues pertaining to dust, noise we already have precedents that they are nuisance, but not interference with television reception. It doesn't fall in any one of the categories that the House of Lords, okay, right, restructured. So it was held by analogy to cases which refused liability for blocking a view, that the defendants were free to build what they wanted on their land, subject to planning controls and proprietary restrictions such as easements over the land. So you can't sue the person just because your view is affected, your reception is affected. So complaints could thus only be made at the planning stage and not by means of the tort of private nuisance. So at the planning stage, you want to complain, you can go ahead with the authorities, but not after it has been built and already been, permission already been granted and then you wanted to sue under tort of private nuisance. Now, first question answered. Second question, even if the court agreed that, yeah, this is the type of nuisance, who could sue? Right? The traditional view in Malone and Lasky was approved, right? As it stands. That is according to Lord Gore, as it stands. So here, the Barnett and Chelsea's case was also highlighted by the examiner. The reason Barnett and Chelsea case was highlighted is because we need to identify the damage element part, whether there is a causation involved here or not. Okay, not only the foreseeability of damage, but there must be a causal link between the nuisance and also nuisance created and also harm suffered. And since there is a negligence issue, we must also highlight, okay, whether the relevant problem over here is caused by the aggravated, sorry, exposure to sewerage water. So the but-for test must be determined, right? Because if but-for test fail, then Martina cannot argue that she is suffering from the pain, and that has been caused by the cold spring. Because sometimes you remember when we talk about causation, we also use other tests such as material contribution tests. So we need to identify what test to be used. We cannot use material contribution here. We can only use but-for test. So if it is materially contributing, doesn't mean that Martina is the cold spring water will be liable. It must be on a balance of probability that the exposure of sewerage water has substantially above 50%, I mean, caused Martina to suffer. So, but for part is relevant because of the inhalation, okay? The kind of causation issue we need to take note of. Other than that, for the other claimants, that is fine. Not so much so of an issue to discuss, okay? So a simple understanding of but-for test is seeking to identify what is the cause of, in fact, and what is simply relevant of. Courts often rely on the but-for test. This poses a question: would the claimant not have suffered harm but for the defendant's negligence, i.e., in the absence of defendant's negligence, would she have avoided the harm? Okay, and we have the case of AGPYA queries, which is relevant for this question, especially the public nuisance, whereby, okay, the residents been affected by the smell. So materially affects the reasonable comfort and convenience of life of a class of a majesty subject, a class of people being affected. As stated in AGPYA queries, does not specifically affect the claimant's land, or the claimant does not have the required interest to land, right, to found an action in private nuisance. So the claimant has suffered special damage. That's good enough already under public nuisance, right? Or rather, and the action also taken on behalf of the community at large. So we have an issue here. So if it is an individual claimant, there are two main concerns. Has the nuisance affected a class? No means cannot. Public nuisance cannot, generally speaking. However, is there a special damage? We need to ask ourselves also. So special damage consists of a damage in excess of what suffered by the public at large. It must be direct and substantial and covers personal injury, property damage, loss of custom or business. It is claim, delay, or inconvenience. Look at the categories: personal injury, property damage, loss of custom or business, and it is claim, delay, and inconvenience. So AGPYA queries will be the authority for public nuisance, even if there is a personal injury or property damage, or if your business is affected. Yes, public nuisance. You can sue under public nuisance. This is an authority. Follow? Okay. Having said that, next authority in hand, which is relevant, will be the case of Bar against BIFA Waste Services Limited 2012. New case, where in this case, operators of a waste tip started to process pre-treated waste. So why this case is important? Because sometimes when we talk about sewage, wastage, chemical, smell, then we are trying to highlight relevant cases based on the facts. We are not talking about factors. We are talking about relevant based on the facts. These are the cases. Okay. There was more smelly than the sorts of refuse that they had previously processed at the site. Raised an important question. Will a use of land be held to be reasonable when it has been permitted by regulators of the activity? So the matter went to Justice Colson at first instance, where his lordship is, Mr. Justice reasoned out that the large-scale tipping of waste as landfill is a necessity of modern society. And the best, perhaps the only way in which non-recyclable waste can be disposed of without causing significant harm to the environment. And that, consequently, a waste tip would be a reasonable use of land if it operated in accordance with permits granted by Environment Agency. Right? So in the judgment, in the judge's opinion, this approach avoided the unsatisfactory position of common law liability for private nuisance being out of step with a statutory framework regulating waste tips. So we need to compare and see whether this is a form of regulatory product that they are doing. Yes, they are operating a sewage management service in the village. So it's looked like a kind of a service, authorized by the authorities. They need to manage it, right? But the question now is, it is overflowing. When it is overflowing, it causes harm. It's not something that you cannot do anything about compared to wasting. This one you can not do anything. But overflow of the sewerage is something that we can avoid. This is a comparison we can make factually based on the case of Bar and Bifar. All right. And then moving forward to another authority, of course, Rylance and Fletcher becomes relevant already. The classic statement of Rylance Fletcher already been given by Justice Blackburn in the Court of Exchequer Chamber, where the rule of law is that the person who for his own purposes bring on his land and collects and keep there anything likely to do mischief. Now, this is what we call the non-natural user of the land, in the House of Lords, Lord Keynes mentioned, and also, endorsed again and explained by Lord Hoffman in the case of Transco PLC. Those are the other cases that you may have experienced under Rylance and Fletcher. And likely to do mischief if it escape must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of the escape. Of course, this part need to be eliminated. It's no longer a natural consequence of the escape, but the test of reasonable foreseeability of the type of damage must be observed, as highlighted by Lord Gough in the case of Cambridge Waterworks against Eastern Counties Leather. But of course, key case is Rylance and Fletcher to start off with, but students need to add the case of Cambridge Waterworks to show that the test of reasonable foreseeability of a kind of damage is important under Rylance and Fletcher. I hope you can recall what I'm saying that we have done on those cases. Another significant case to highlight on the aspect of non-natural user, as I mentioned just now, the case of Transco PLC against Stockport Metropolitan. Lord Hoffman suggested that a useful guide in deciding whether the risk has been created by a non-natural user of the land is therefore to ask whether the damage which eventuated was something against which the occupier could reasonably be expected to have insured himself, right? So occupier, you're accumulating something. Are you insuring it? Or is this something that you are ignoring, right? Like, for example, you are keeping some chemical, and this chemical will be very toxic. It's not a pail of chemical, but is tongs, tongs, like containers, many containers of chemical. Definitely, you should have insured yourself to ensure that other people are not affecting. You need to find yourself, okay, to be very careful that other peoples are not affected because they are called non-natural user of land. Anything can cause harm to the neighbor can be a non-natural user of land. Anything that non-naturally brought to your land or naturally on the land considered to be a non-natural user of the land. Yeah, quite controversial, but we will identify it soon. Another case highlighted by the examiner for this question was the case of Marsick against Thames Water, where this case recognized the potential for huge public liability in such actions and citing both statutory authority as well as a wide margin of appreciation for individual states given by the European Court of Human Rights have refused to permit Article 8 to have much impact in this area. So, what is the facts? Peter Marsick brought a claim against a statutory water and sewage undertaker, similar to our friend here, sewage undertaker, Thames Water, complaining of its failure since 1992 to prevent persistent external flooding and backflow of foul water from its sewer system into his home at times of heavy rain. At times of heavy rain. Although it was reasonably practicable for TWL to prevent the flooding, it has refused to do so. When someone refuses, sometimes we can see the issue of malice. Knowledge, you know somebody is affected, you refuse to do. Under its then scheme of priorities, there was no prospect of such works being undertaken in the foreseeable future. After 9 years, Marsick turned to law and brought this action for damage to his property in nuisance and under 1998 Human Rights Act. Although his claim in private nuisance was rejected at first instance as contrary to the existing authority, Judge Havry QC had approved the claim under Human Rights Act 1998, founded on infringement of claimant's right to private and family life under Article 8 and peaceful enjoyment of his possessions under Article 1 of the Protocol 1, the first protocol. So that was the first one, peaceful enjoyment of his possession. So successful. But again, there was an appeal to the Court of Appeal. And here the Court of Appeal in supporting Marsick's claim in private nuisance rendered any claim under the Act is unnecessary, which means the Court of Appeal said it is rightful for us to allow a claim under private nuisance. So we don't have to take concern about Human Rights Act. If you fail in private nuisance, then possibly you can argue under Human Rights Act. Okay. These are the authorities. The common errors, okay, for problem question, particularly in this question, the most common error is to focus almost exclusively on private nuisance. No, you shouldn't do that. Please give some form of leverage, okay, on the areas, and to omit public nuisance and violence and fracture completely. Candidates who consider violence usually conclude wrongly that the usage in question was non-natural, irrespective of the rulings in Trustco. Some candidates forget that personal injury is not actionable under private. So do not forget all these are warnings that has been highlighted by the examiner. So if you want to consider a good answer, you need to consider all possible cause of action and include the issues of defenses and remedies. You need to include defenses and remedies. According to Marsick, if CW were found to be a statutory service that provides its own complaints procedure, then balancing the rights of individual against those of the community, then neither a common law nuisance claim or HRA claim would be successful. But good organization possibly based around the different types of damage, and clear writings are always important. So these are some of the advisors and also the poor answer to the question, right, given by the examiner. So what we can do is you can take a break in between while you're having a break. If you have any questions pertaining to this particular question, right, feel free to chat, put it in the chat column. After the break, we are going to look into the guidelines based on the facts alone, guideline based on the facts alone. We'll take a short breather. I'll see you in a short one. It's about 5 to 10 minutes. 5 to 10 minutes. Okay, hi everyone, welcome back. Okay, there's no question. So let's move on. Let's move on from where we stopped just now. Okay, so this will be the answer guideline where this question presented, okay, the question presented involve multiple potential causes of action arising from the overflow of sewage into properties in Longfield by cold spring water, including issues of private and public nuisance, potential liability under violence and Fletcher and negligence. This what you can highlight, okay, to the examiner. And as far as introduction is concerned, this is basically what I've highlighted above, but you are highlighting it eventually under introduction. Briefly outline the factual background. Okay, so you need to briefly outline the factual background and also who have been affected here. Okay, for example, Fred and Gladys' property being affected, health of the residents around, that includes Martina, and so forth. So state the potential legal issues, and let's start off with private nuisance, for example. And what is private nuisance? Unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. So application to Fred and Gladys. So when we look into Fred and Gladys issue, they have a clear interest in the land as home owners, because what we can presume here is they've been living there for 20 or years. If they are tenant or also they cannot be a licensee for living for 20 years anyway. Okay, it's very unlikely. So the sewage overflow constitute a direct, substantial, and unreasonable interference. It is possible, okay, with their use and enjoyment of land. So we need to cite first Malone and Lasky and Hunter and Canary Wharf to show that, okay, they have the right and the necessity of land interest and also nuisance claim. But at the same time, you can also, okay, highlight the balance, okay, of convenience, citing Bamford against Thurnley, right? Can be upset by Cold Springs action because this seems to be quite substantial, overflow of the sewage. However, to further confirm yourself whether this is possible, you can actually add, you need to add the factors. Now, by highlighting this is unreasonable or it is reasonable or not. Highlighting the factors, for example, was there a malice? Okay, I don't think so on the facts there's a malice involved, because there's no such thing called like they knew and people has complained and they refused to know. No such thing happened there. Number two, you can also look into the duration is one of the factors to be considered. Autumn and spring, right? So in a year, okay, out of 12 months, 6 months, residents been affected. That is considered to be unreasonable. Okay, the cases, Royal Hotel against Spices Brothers. So you can add those cases. And what about the sensitivity? Yes, sewage. And sewage has actually affected Rose Bush Garden. So whether this is a normal sensitivity or abnormal sensitivity, that is something that we need to observe, right? So if this sewage can harm any plants, then roses are considered to be a normal sensitive plant, not to say abnormal sensitive plant. It's a normal sensitive plant. And normal sensitive plants such as roses were affected, shows that this is not an abnormal sensitivity, this is a normal sensitivity. Okay, McKinnon, and also the case of forgot already, there's one more case that I actually highlighted just now. Is there down here? I'm also going to highlight to you just to recollect back. So factors are important. And what about the locality? Village area. Village area is more like a residential area. So no issues on the locality. So all in all, okay, we can see that private nuisance may be affected, right? But Martina having a problem. She lacked the interest in the land. Likely cannot claim under private nuisance directly. Okay. She could potentially argue for indirect effects if she has suffered special damage beyond that suffered by the general public. If it is an indirect effect, then possibly. But if it is by the general public as a whole, then she may be able to argue under that category. So what is the difficulty posed by the requirement of an interest in the land? You can highlight the cases which either you highlight it earlier itself or under the category of private nuisance, you can also highlight it. So Martina's main problem is interest in the land and also the type of harm. Moving on to public nuisance. Definition: an act materially affects the reasonable comfort and convenience of life of a community in general. By definition, you can use AGPYA queries if you want to use a quoted definition, which I've given to you in my notes. So what is it? How do we apply to the situation? The repeated overflows affecting Longfield could constitute a public nuisance affecting a significant portion of the community. And Martina could be one of them if she want to put herself under the public nuisance. Could claim if they can prove special damage. So on the facts, okay, there can be a special damage here because the class of the majesty is affected. The group of people being affected by the smell. Okay, I think you can imagine a smell, a society, people, residents cannot stay, definitely. It's not going to be easy for them to stay there. Coming to Rylance and Fletcher, the principle that we are looking at, a person who for his own purposes bring onto his land and collects and keeps there anything likely to do mischief if it escapes. Okay, Lord Blackburn, right, in Rylance and Fletcher itself. Application. Cold Springs management of sewage fits the criteria of bringing and keeping something likely to do mischief if it escapes. So the natural consequence of the sewage overflow directly damage Fred and Gladys' property. But at this juncture, students may want to ensure that you meet the latest requirement, the test of reasonable foreseeability must be satisfied of damage must be satisfied as per Lord Gough in Cambridge Waterworks against Eastern Counties Leather. Sorry, Eastern Counties Leather. So you can add this case to ensure that you are trying to satisfy the requirement. We must also be able to satisfy the requirement of non-natural user of the land. Sewage water, can it be considered to be a non-natural use of the land? Okay, modern interpretation as per Transco against Stockport. It's not something that is naturally used in the land. It might be considered as non-natural use of the land because you are changing the landscape and then you are treating the water in the plant considered to be a non-natural use of the land because the sewage can cause harm, right, when it overflows or when it escapes. So that is something that you can, but other requirement you can add in your answer, okay, like for example, escape, Reed and Lyons, increased harm, okay, as in Ricketts and Lothian, no problem. But what I'm trying to highlight to you is the core of the application is very important, okay, in developing your answer to gain the highest mark, high-end marks. I think majority of you're fine because I remember marking, don't know whether all of your assignment or some of your assignments, or rather the mock exam papers. I think I was given about 6 or 7 papers of yours, and majority of yours scored quite well. I think 55 and above, if I'm not mistaken. That's good, but it's just that you need to increase the target to scoring an A if you would like to do that. I've given some comments there, so maybe you can utilize it. Okay, negligence. Coming to negligence, part of it, yeah, as usual, duty of care, breach of duty of care, causation and remoteness, application to the law. Cold Spring owes a duty of care to Fred and Gladys and potentially other residents, including Martina, to manage sewage without causing harm. If they fail in public nuisance or private nuisance, then alternatively, we have negligence to be argued. And failing to prevent, okay, the sewage overflow despite it occurring repeatedly. This can be a breach part of it. Did not take necessary precaution, like Latimer and AAC that you have done under negligence, you can utilize here. Okay, and harm suffered can be greater, right? Gravity of harm or frequency of it happening also high, 2 seasons in a year. Then we go into but for test, Barnett and Chelsea must establish that, okay, they would not have suffered that harm, okay, but for Cold Springs and negligence. Because when you talk about road vehicle accidents is easier, but for test can be satisfied. But this is like, you know, something like exposure, something like you are absorbing, you're smelling. So it's more like a materially increasing risk kind of thing. So that is why the law proper, again, you can't use the material increase the risk test. You cannot use material contribution, but you must use Barnett and Chelsea. So on the facts, we need to determine whether that has actually, on a balance of probability, has increased, has affected the class of residents there or not. So, of course, property damage to Fred and Gladys and possible health impacts on Martina and other residents, okay, considered to be a situation where it's a kind of damage that can be said to be foreseeable. Wagon mount, number 2, can be used here, okay, for nuisance. Wagon mount number 2 can be used here for nuisance to prove damage. But of course, you don't, I'm sorry, wagon mount number 1, not number 2, because this is negligence. We are talking about negligence here. Wagon mount number 1. All right. So having established the liability, then we look into the defenses and remedies. So when we talk about defenses and remedies, then the key case over here, we are going to utilize bar and BFAR. Discuss any possible defenses Cold Spring might raise, including statutory authority or regulatory compliance, referring to bar against BFAR, waters, waste services. So should there be a proper defense for bar and BFAR or not? So we need to argue, right, by using the authority I've actually given based on the facts. Any decision will do, because I don't give decision in my outline. It depends on your argument, what argument you want to put forward, and you decide whether defenses are likely successful. If the defenses are not likely, then we explore the remedies. What is the type of remedies? Injunction, yes. I think the type of remedies will be injunction is more appropriate instead of damages. They can't be giving damages and when people are continuing to suffer harm, right? So I think injunction relief is better to prevent future overflows. They just need to do something to prevent overflows in future. That's what they need to do. So we need to make a conclusion by summarizing the whole process. Okay. Right. This is how you can analyze first question in 2023. Do you have anything else to add, to ask for discussion purposes? If I would have missed out, or you just want to double check whether anything that you can add to this? I give you maybe a couple of seconds here before we move on to second question. No? Okay. Another question under zone B. With permission of local council. With permission of local council. It's not a statutory authority, but permission. The Youngstown Rugby Club has begun to hold fundraising car boot sales every weekend on their club grounds, next to a small industrial estate in Youngstown. next to a small industrial estate. Every Sunday, cars pour into the area from all over the country. Local residents feel that the area has completely changed due to the noise and traffic. Due to noise and traffic, what that got to do with nuisance? Never mind. Let's highlight that. The sale visitors often drop rubbish on the club. Sale visitors often drop rubbish on the club, some of which blown into the garden of the White Hart Inn, which is next door to the club. So possibly they would like to argue about White Rylance and Fletcher here. Huh? When the owners of the inn complain, there was a complaint made, club ceases to empty the waste bins, which means there is an issue of malice. They know that people do not like it, but the club refused to do anything. Okay, because the rats are drawn in the bins, okay, some of which are straying into the ground of the inns. So rats are straying into the grounds of the inn. Inn is more like a place where people go. See, so you go to a restaurant, you don't like to see a rat. You go to a hotel, you don't like to see a rat. This is going to affect their business. That's what we can see from here. General remark again. This is a popular, straightforward question. Raises standard issues of nuisance, public nuisance and private nuisance, Rylance and Fletcher, and negligence possibly. Nuisance problem question almost always include these four aspects. Now, cases like Bamford, I've already discussed with you. Malone and Lasky discussed already. The other case that the examiner highlighted, which I would like to take note, okay, will be the case of Christie and Davy, which is relevant to the facts here, where the state of mind of the defendant would also seem to be relevant in assessing whether defendant's use of their land is reasonable or not. Here, the plaintiff succeeded in obtaining an injunction when a neighbor, frustrated by noise of music lessons in a home, expressed his annoyance by knocking on the party wall, beating trays, whistling, and shrieking. So Justice Nott said in this case, what was done by the defendant was done only for the purpose of annoyance, and in my opinion, it was not a legitimate use of the defendant's house. So malice can be seen here, right? So this is how you can identify that is relevant for the facts over here, right? Besides AGPYA, bar BIFA we discussed, which are relevant to the facts, Rylance, Fletcher, Transco, there's another case that is different from the earlier question, which is relevant here, is Adams and Ursel. The defendant ran a fried fish shop in a residential part of a street. So the court granted an injunction restraining the defendant from carrying on his fried fish business on the premise, and rejected the argument that the closure of the shop would cause great hardship to the defendant and to his customers, so for whom it was a cheap source of nourishment. So here, an injunction can be granted for you not to continue with the business. So we are concerned about our friend here, whether they can actually run these boot sales or not. Okay, they are already a rugby club. Okay, they have a pitch, they have their games and matches. But this is like, weekend boot sales club, which is not part of their ordinary business. All right. So hence, we need to ask ourselves whether injunction can be granted over here. Right. Adams and Ursel and other cases for the matter. Other than that, notable cases for this question on injunction side of it, again, Canaway and Thompson. In 1969, the claimant built a house near a man-made lake, which for a number of years had been used for a motor boat racing. The man-made lake was used for motor boat racing. So now the defendant were liable for the nuisance created by the noise. And at first instance, the claimant was awarded damages of 16,000 instead of injunction. There was liability, but damages was granted, not injunction, because the losses is very trivial, not so much for the defendant to pay, because they are running a big business, motorboat racing. So, of course, the claimant appealed. On appeal, the claimant was entitled, appellate court said that the claimant was entitled to an injunction, not a mandatory complete injunction, but limitation. We call it as a quiet time-made injunction. Interim, not interim, certain period you don't do. If you're running a motorboat racing for 7 days, you cut it to 5 days, Okay, you're running it at night, you cut it to daytime. So that's called injunction. The use of the lake in certain days, to certain days and to certain noise limits. So here, factually, the plaintiff would be awarded an injunction against power boat racing on a nearby lake, regardless of any public interest. So which means the defense of public interest is not available here. And regardless of the fact that she had chosen to build a house near the lake in the knowledge that some racing took place, coming to nuisance, regardless, the court will not consider as a defense. She wants to go and stay there, let her stay there. She can sue, no problem. Nevertheless, the injunction was awarded on term, as I said just now. The court used its discretion to stipulate a strict timetable for international, national, and club events, thereby allowing the racing to continue in a limited form. By such means, and also by using their power to suspend the injunction to give the defendant the opportunity to remedy the nuisance. The courts recognize and balance the competing interests, competing rights of the litigant. So that is a significance of Kennaway and Thompson when you want to discuss about injunctions. Okay. Another case you can also utilize will be the case of Gillingham against Medway. In brief, Justice Buckley held in this case that planning permission to develop a disused naval dockyard as a 24-hour commercial dock had changed the character of the neighborhood. So local residents, therefore, could not complain. So these were the case they said that planning permission had already changed the character. So when the planning permission changed the character of the neighborhood, can claimants sue or not? Gillingham says no. So what about Supreme Court in Coventry and Lawrence? Supreme Court in Coventry and Lawrence reviewed the extent to which planning permission might change the character of the neighborhood, where defendants had long-standing planning permission to build a speedway, racing stadium, and a later permission for a motocross track. So here also in Coventry, there was a planning permission. So Lawrence, who had moved into the area in 2006, alleged that there was a noise. Okay, the Supreme Court overturned the decision of the Court of Appeal that the grant of planning permission had by itself changed the nature of locality. It would be wrong in principle if, through the grant of planning permission, a planning authority would be able to deprive property owner of a right to object to what would otherwise be a nuisance without providing her with compensation. So Coventry is a significant decision to tell us that granting planning permission alone will not change the character of the neighborhood. The court will look into various other perspective or evidence from the facts, okay, on the ground itself, the locality itself, before deciding whether the character of the neighborhood has completely changed before allowing such activity to take place without any interference. If not, if people are complaining, defendant can still be responsible. So question A and question B, question 1 and 2, the first one and second one, some of the cases can be interchangeably used, but provided that to see how. But here more intensely, we are using this because of the issue of spots. All right. The earlier one is sewage. It's quite distinct, quite different kind of a situation, right? That is why Kennaway and Thompson became relevant. Coventry and Lawrence became relevant. Gillingham and Medway became relevant for discussion. Common errors. Focus almost exclusively on private nuisance and omitting Rylance and Fletcher completely. No, shouldn't. Good answer to this question would consider all possible causes of action, right? A good candidate will engage the impact of co-entry on, because there was a planning permission issue in this question. So look for this kind of important gist of the facts to see any specific cases reflecting that, aside from the general structure, general cases that we must always use. Okay. This is the significance of this question. And answer guideline, brief description of the facts, as usual, outline the potential legal issues, definition of private nuisance. We need to apply increased noise and traffic. So we can cite Canaway Thompson for noise nuisance and the court's discretion to grant injunction with terms that balance competing interests, right? Litter and rat infestation. We reflect Christie and Davy regarding the defendant's conduct exacerbating, right, nuisance, suggesting a deliberate worsening of the condition by the rugby club. So discuss the significance of the landowner's state of mind and actions post-complaint which exacerbate the nuisance. So there's a high possibility that nuisance could have been committed, right, in both accounts. Okay, litter and rat infestation is possible. Increased noise and traffic is also possible. Defenses. Explore possible defenses the rugby club may have, including coming to nuisance, which is not applicable definitely. Okay. Discuss remedies, including injunctive relief, which I already highlighted the cases for you to apply it, right? So on the approach to defenses and remedies. Next is coming to public nuisance issue. As usual, definition, application, the car boot sales impact on local residents. So, and traffic may constitute a public nuisance. Is the damage substantial? Possible. We can cite cases like Tate and Lyle Industries earlier, St. Augustine links cases, okay? All those additional cases you can utilize under public nuisance. But of course, the key case is AG against PYA quarries. Thirdly, negligence. Rat infestation that you may want to discuss for negligence. Under negligence, the cessation of waste management leading to rat infestation can be seen as a negligent act, especially after complaints were raised. So duty of care should have been owed by the rugby club to these owners, and breach of the duty by exacerbating the rat problem. They never do anything to overcome the rat problem. The more you ignore, the more rats will grow. Okay, population will increase. And the direct causation linked to the club's inaction to the infestation, omission liability. Not doing anything. So potential damages, yes. Any additional harm, additional cost incurred by the inn due to the infestation, right? What we call hygienic, keeping it hygienic, definitely, right? Will avail for a additional cost. So the fourth one, of course, negligence. Rylance and Fletcher, if you want to discuss, applicable or not, accumulation of rubbish. You may want to discuss about rubbish being blown away to the neighborhood. And also rat infestation. Rats are escaping to the neighborhood. So here, yes and no answer, but here it is suggested that rubbish and also the rat infestation is not to be considered a non-natural use, right? You are not accumulating rat anyway, right? That's natural, okay, observation that we can see. Okay, naturally rat will come. And accumulation of rubbish also is not a non-natural use. People accumulate rubbish and it is not escape. It is blown away. Okay, so that's the issue of escape you need to argue. Blowing away rubbish can be a part of escape or not. If it is not, it's okay. If it is yes, also can be argued. But looking at the gravity of the facts, when you look into the rubbish in itself, can that be considered as an escape? The sale visitor dropped rubbish on the club grounds, some of which has blown into the garden of the White Hart Inn. All right. That's all. Blown into the garden. Oh, very sorry. It's because of the antibiotic I'm taking. It's giving me a slight drowsiness. Okay. Yes, possible for you to discuss Rylance and Fletcher over here. Rylance and Fletcher over here. That is possible. But the only problem you may face is a non-natural use of the land. So contrast with negligence is a more fitting legal framework for this. Negligence much more appropriate. But you need to highlight also Rylance and Fletcher to tell the examiner that this is unlikely. Okay, a bit of defenses that I've actually highlighted that need to argue also. Gillingham, Coventry. Examine whether local council permission for the car boot sales changes the character or not. Yes means different, no means different answer. So yes means we follow Gillingham, and if it is no, then we follow Coventry and Lawrence. So as a conclusion, we need to summarize the potential for success in claims based on private and public nuisance and negligence against the Youngstown Rugby Club. Highlight the need for detailed examination of the facts, especially regarding the conduct of the rugby club post-complaint and the balance of interest between the rugby club's fundraising activities and the rights of White Hart Inn and local residents to quiet enjoyment of their purpose. So you're making a conclusion as a whole. What do you think based on the overall discussion of the facts and the law at hand on nuisance and other torts here? Okay, so this is basically a brief guideline to tell you the framework that you can have, and you can actually work on this guideline by incorporating your discussion, your argument, your other cases that you naturally already, okay, from our lecture, right, that we have done today, and also earlier when you have done with I don't know whether it was me or my counterpart. Okay, having said that, we are going to run through only. I'm not going to go into detail. Maybe some of the cases I'll highlight to recollect your mind, or maybe certain cases might not have mentioned earlier, so you may want to reflect here. Okay, just to run through the case to understand, to see where the issues are. Tracy and Mike, because I'm going to focus on essay later, so I need time for that. Tracy and Mike have been recently moved into a cottage. Recently moved. So coming to nuisance will be an issue, right? Recently moved into a cottage surrounded by farmland. We don't know. Most likely they are the owners. At the edge of the scenic village, Birchwood, they soon identified coming to nuisance. Issue will be here. And these guys need to check on their proprietary interest in the land. At the edge of the scenic village of Birchwood, they soon find that they are disturbed by sounds. Sounds and noise. Students can use cases like Harris and James, maybe. Harris against James. Right? Being operated by the local farmer Dave in the fields behind the cottage. During harvesting time, the machinery operates late into the night. Late into the night. Duration issue. There are two cases. One is Harrison and Southward. Contrast the case with D cases Royal Hotel. Okay, in short, and prevents Tracy and Mike from sleeping. So this is comfort is affected. When they complain to Dave about the noise, Dave retaliates. Okay, so Dave retaliates. When Dave retaliating, then this is more of Christy and Davy situation. Right? Christy and Davy. By extending and harvesting hours, I mean, this is malice. Extending means, harvesting hours means there's a malice involved. Malice involved. And now commences in the very early morning. These malice cases that you want to know me, maybe Hollywood Silver Fox or Bradford Robinson better. Bradford against Robinson Rentals. Okay, over here. And then this disrupt traces meditation practice. Meditation practice. So meditation practice is something that students need to take note. Is it abnormal sensitive? Abnormal sensitive activity, where normally people won't find it, okay? Don't find it nuisance, but people who are doing meditation may need a too quiet environment. So she can be abnormally sensitive in this kind of situation. Their next door neighbor, Anita, keeps a large number of chickens in the back garden. They are free range and often stray into Trey's flower beds. So Anita, case chicken strays, probably Rylance and Fletcher or negligence. Rylance and Fletcher or negligence. Destroying her valuable rose bushes. Yeah, property damage. Mike suffers badly from hay fever due to pollen. So this is due to pollen is a personal injury, PI, yeah? Personal injury. Can you sue under Rylance and Fletcher or nuisance? No, you can't. From the crops being grown in surrounding fields owned by Dave. And this is a particular issue in the spring and early summer. So I believe that when you are suffering from hay fever, personal injury is not claimable. Possibly you may want to argue under negligence instead of nuisance. Negligence instead of nuisance. So these are the overall quick issues that you can discover from the question at hand. Can I erase now? I think you got it. I'm going to erase. Okay, yeah. It's a problem question, standard of issues, nuisance, Rylance and Fletcher, and possibly negligence. I've given you the guideline for you to read for each of them. For Mike, law cases and reports, Malone, Lasky, Hunter, Canary Wharf, Christie and Davy, Robinson and Kilward, sensitivity, right? A bit of a recollection of Robinson, Kilward. If the complaint is based on the abnormal sensitivity of the claimant, the court will not interfere. This would offer the claimant far too much protection at the defendant's expense, right? You can actually contrast it with McKinnon, where we are talking about, right? The losses can be given full extent if it is not an abnormal sensitivity, okay? Sturgis and Bridgman is important on the locality, okay, right? D cases, Royal Hotel and Harrison, I mentioned about the duration. Another case that you may also want to take note together with the other case here will be St. Helen against Tipping. So here the courts are more willing to find nuisance where physical damage to property has been caused. You see there they have hay fever. So this is where you can use St. Helen against Tipping to show that physical damage to property, right, is something where the court is willing to provide damages. And tend to ignore factors such as nature of the locality. So personal discomfort will normally have to be substantial to merit a response. As seen in Walter and Selfie and St. Helens Smelting Company against Tipping, mere personal discomfort will be treated as with latitude unless the interference is such that is materially interfering with the ordinary comfort or physically of human existence, not mere discomfort. Remember the meditation part of it? Mere discomfort is not substantial discomfort because you can balance it objectively for those normal residents there. Yeah. So for that account, you can use cases like St. Helen Tipping and also Walter and Selfie. Rylance and Fletcher, Ricketts and Lothian. It is not every use to which land put that things brings into Rylance and Fletcher principle. It must be some special use bringing, then only it can become a Rylance and Fletcher. No, chicken all knows there's no special use now, right? They are normal, ordinary use of the land. It means that you cannot because the farmland, right? This is how you can compare and see, right? But Lord Hoffman gave a useful guide. right? Which I mentioned just now also. Public nuisance, AGPYA queries as usual. And defenses, some of the defenses I've actually highlighted here. Good defenses are prescription, statutory authority. The other two defenses are not good defenses, remedies, injunction, or damages. So you can read the sample approach I've given to you, right, on this part. The student approach, not minor, student approach. Okay, next question. Quick identification of the issues. A small block of expensive flats has recently been completed near to St. David's Castle, a popular tourist attraction. Near to St. David's Castle, a popular tourist attraction. A small block of recently been completed. Okay, so, and then you have a castle. Tourist attraction in the center of the coastal town of Seaview. Ahmed family has moved into one of these flats, which features large glass doors that open onto a wrap-around balcony. The family are distressed to discover that visitors to the castle are peering into their home with binoculars. Mr. Ahmed has complained to Historic Britain, who owns the castle, but it claims that it can do nothing. When Mr. Ahmad threatens legal action, Historic Britain responds by installing viewing telescopes on the castle ramparts, which causes significant worsening of this apparent breach of privacy. Historic Britain has now begun staging historic reenactment in the castle grounds that weekend. These involve the firing of cannons, the noise of which is particularly distressing to the inhabitants of the Seaview and the residents of the Veterans Hospital in the Seaview. Advise the parties. 2022 Zone B. Does this ring any bell to you? Can you imagine any case that similar to this situation? Anyone? Yes, no? Any answer? Can I have some feedback from you? Yes, no, not sure. Just a quick recall and see, remember anything? My question is whether the facts of this case recalls any of the cases that you learned. Do you think I can get some answers? Yes, no, not sure. Nobody? So it was 2022 May question. All right. It's about viewing. Am I right? By using telescope lens. So was there an issue of breach of privacy? Was there an issue of nuisance? That was argued, right, in this hypothetical question given by the examiner. So in this regard, I would like to highlight to you the authority that I actually incorporated in my notes, okay, during revision. Let me go down right at the bottom. And I don't know whether I've incorporated the Supreme Court decision or not. Okay, never mind. Okay, please look at it. This is 2022 question, and the case was decided by the Court of Appeal in 2020. Do you see that? Case was decided by the Court of Appeal in 2020. There was no cause of action that existed in respect of private nuisance for overlooking. The instant case was more akin to an invasion of privacy rather than nuisance, and Parliament should be the body to legislate that area rather than courts. It was not appropriate to use Article 8 of the European Convention on Human Rights to extend the common law in that respect. So what happened? In this Fern against Board of Trustees of the Tate Gallery, right, a block of flats, similar to the facts of the question, 2022, a block of flats were in a development adjacent to a new extension of the Tate Modern Gallery. Each flat comprised a general living space and a triangular end piece known as a winter garden. The winter garden had floor-to-ceiling windows, and although they had been conceived by developers as a form of indoor balcony, a number of tenants used this garden as part of their living accommodation. People changed the style of the house, you see? Right, 5 tenants in the block were the claimants in this matter. What happened? The Tate Gallery had built a viewing gallery around all 4 sides of the top floor, which was open to visitors. Those visitors using the gallery, not only seeing the gallery, they like to see the view outside. The other day, I was in a KL Central for a event. In Malaysia, we have this Hari Raya, the Malay celebration. So we have actually invited people from the immigration department, from officers from investigation, police investigators, and also prosecution agencies for this dinner, because we are also lawyers here. So we have, went to the top penthouse, and we were seeing, we are having some food and drinks, But at the same time, you see, the top floor is accommodative for viewing. People love to view around. So that is part and parcel of the kind of a setup made, okay, by the galleries or, hotels here. This was a hotel. So this is where the gallery, which has been built, okay, with a viewing gallery around all 4 sides of the top floor, which was open to visitors. And those visitors using the gallery had an uninterrupted view of living areas of the flats, looking in and sometimes using cameras and binoculars. So the issue was whether there was an infringement of rights under Human Rights Act, Article 8. Okay, we have done with it yesterday. And at the same time, okay, can it be a nuisance or not? So these are the possible arguments that we need to look at it. Okay, whether you can establish nuisance and whether you can argue under Article 8. First instance, Justice Mann found that although there was a great degree of intrusion into the flats, the privacy claim under Article 8 failed. Right? None of the factors raised by the tenants were determinative of this question and had to be viewed as a part of global assessment of the case. Secondly, with regards to the action in private nuisance, overlooking could not amount to an actionable nuisance, and there did not have to be an emanation from one land to another to ground such a cause of action. So overlooking should not amount to a nuisance. Even interference with the television in Hunter and Canary Wharf, okay, was not tantamounted to a nuisance. No, it's not. Right? So the nuisance claim was not made of some reasons given. And the matter went to the appeal to the Court of Appeal. And the Court of Appeal again dismissed the appeal by the tenants, although they disagreed with Justice Mann's number of respect. So Court of Appeal said there was no cause of action in private nuisance for overlooking. Not every annoyance was actionable. And when we talk about overlooking, it would be difficult to apply the objective test in nuisance for determining whether there had been material interference with the amenity value of the land. Okay, when considering whether to extend the common law, then the court was not ready. Because if you want to extend it, you must add new types of nuisance already. Courts were not ready for that. Rather, they feel that this is more akin to an invasion of privacy rather than tort of nuisance. So we leave it to Parliament. Okay, we leave it to Parliament at that point. All these are points of discussion made. And this was the last year's pre-exam update, previous pre-exam updates for you to read. Okay. Having said that, after the break, I'm going to get into important or significant part of discussion that targeting on nuisance this year. Whether the examiner may give you a problem question on privacy law, okay, or can it be a mixed question with private nuisance and privacy law? Maybe not, because it can be a full question on nuisance. And I'm actually looking at an essay question on nuisance. There's a reason why I'm looking at it that way, right? Essay question on nuisance, because of the significant or rather landmark decision made quite recently in 2023. So we are going to go into that, and then we are going to reflect ourselves one of the essay question and the guidelines pertaining to essay question before we will end the session on nuisance. Public body is not a popular area. Okay, I will run through fast. Even tomorrow, I'll run through fast. And last two sittings, okay, or 2 years, okay, there were no questions on public bodies. And most of the students, they find it difficult to answer public body question because very, very factual and uncertain. Very, very factual and uncertain in terms of the development of the law, right? So having said that, we will take a breather and we will meet up between 5 to 7 minutes time. Hi, everyone. Welcome back. Okay, we are getting into the final session for today. As I mentioned just now, as far as update is concerned, okay, particularly on the part of nuisance, how the what we call the focus may be for this year, right? Knowing the fact that in the case of Fern, right, and the gallery, the what we call after the decision made by the Court of Appeal in 2020, right, the claimant made further appeal to the Supreme Court. The claimant made further appeal to the Supreme Court. So I'm going to give you the judgment. I'm going to show you the judgment, but eventually I'm going to attach it, right, to your notes so that you are what we call this able to understand, okay, how the latest development was. Okay, right. Let's look into that part. This is a Supreme Court decision in 2023, 2023, which was a long-awaited judgment, okay, handed down on 1st February last year, right? Providing a helpful restatement of the principles of private nuisance in overturning Supreme Court, okay, surprisingly, right, overturned the Court of Appeal decision on this area, and finding that visual intrusion now is capable of giving rise to liability in nuisance. So, the decision reinstates the principles of private nuisance. In summary, a nuisance is a use of land which is wrongfully interfered with the ordinary use and enjoyment of neighboring land, right? To amount to a nuisance, the interference must be substantial, judged by the standards of the ordinary person. So the Supreme Court overturned the Court of Appeal decision, finding that it was beyond doubt, that Tate's viewing platform constitute substantial interference with the ordinary use and enjoyment of flats, and that Tate is liable in nuisance. That was the decision made. His Lordship said the trial judge found that the claimant's flats are under near constant observation by visitors to viewing platform. It has been estimated some 500 and 600,000 visitors would use the viewing platform, taking photographs and posting on social media. The ordinary person would consider this level of intrusion to be substantial interference with the ordinary use and enjoyment of their home. In contrast, members of public using the platform to admire the view is not a common and ordinary use of Tate land, because that was a gallery. You are not supposed to view outside. You are supposed to see what is inside the gallery. So it's not an ordinary use already on that basis. So that was a summary of the decision made in 2023, right? In 2023. So let me copy and paste it into the existing notes so that I can attach it when I send it to speed. This part, Supreme Court decision. This is an update. Right. Having said that, let's look into one of the hypothetical essay question here. Right. Discuss the different form of nuisance in English law. Compare and contrast public nuisance with private nuisance, considering their key difference and similarity. So we can have this as a guide, one of the guided question, right? It's about public nuisance, private nuisance, and so forth. Because in Tate and Lyle, sorry, not Tate and Lyle, in Fern against Tate Gallery, I think that also can tantamount to a public nuisance. So the examiner may want the students to have some good comparison between public and private nuisance, or the examiner may want to test the student again on a general essay on private nuisance. Let's look into the general essay on private nuisance. Let me pick one of the questions, older questions, right, for you to have a look. Yeah, this one, maybe. Let me check this 2017 problem question before that. Is there any further essay question? Problem 2019 was a problem question. 2020 problem, all problem questions. So there is a high likely that you will see an essay question now, okay, from nuisance, because of the latest decision made last year. So let's get into that past year question on 2017, a bit of an old question here. So this is a relatively straight, okay, highlighting the question again. Evaluate the approach of the courts in resolving conflict over competing uses of land in private nuisance. So as a general remark, this is relatively a straightforward question which requires students to address the frequently advanced justification for balancing private interests against commercial interests and in resolving dispute between neighbors. The guideline is examine critically a selection of following issues. Number one, as an introduction, we are looking at there are two common law torts with the word nuisance in their name. The two forms of nuisance are quite distinct torts and must be considered separately. The first is private nuisance, which deal with the indirect interference affecting the use and enjoyment of land, commonly on that part, such as excessive noise and emission of smells or noxious fumes. It is essentially a remedy for landowners in respect of indirect harm affecting their property. The second is, of course, public nuisance. Has a wider application. It is essentially a form of criminal liability arising from a wide range of antisocial activities, but individual tort actions are limited to claimants who have experienced special damage above and beyond that suffered by rest of the public. In terms of authoritative definition, you can also cite Winfield and Jolowitz, right? Define private nuisance as an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. If you want to quote, you can do that. And as far as type of private nuisance, you can quote the case of Hunter and Canary Wharf, that there are three types of private nuisance. One is physical injury to land, for example, by flooding or noxious fumes. Two, substantial interference with the enjoyment of land, for example, smells, dust, and noise. Third one is, of course, encroachment on neighbor's land, for example, spreading of roots or overhanging branches, which is of minor significance. Okay, the significant part is number two, that is substantial interference with enjoyment of land. So all three forms seek to protect claimants' use and enjoyment of land from an activity or state of affairs which the defendant is responsible. Davy and Harrow Corporation. So now we need to address the question. So looking into the evaluation again, right? Evaluate the approach, how the courts are actually approaching. So this is more of a question to look into approach of the courts in different perspective and the development of what you mean by substantial interference with the quiet peace and enjoyment of land, right? So this time this can be very prominent because of the later decision that we have. Coventry, the first significant case that you can actually highlight, where it concerned an alleged noise nuisance arising from a motorsport stadium for which planning permission had been granted. Why this case is important? Because courts are approaching things in a different way. Yes, there is a defense called statutory authority, but you see, the defendant also should not be held liable because they have actually applied to the local authority for a permission to run certain business. So when local authority is giving them, or other some authorities are giving them the permission, is very much of a regulatory authority. It's quite valid, quite lawful. But when they have used that permission to run their business, they have been sued. So there is some form of uneasiness on the part of the defendant. And when we want to see whether it is justifiable or not, even if a planning permission was granted. So Supreme Court reviewed the law of nuisance and considered that the relationship between planning control and the thought of nuisance. Secondly, the right by prescription to commit a nuisance, and argument that the claimant came to nuisance. So the Supreme Court had to consider the came to argument of coming to nuisance again here, all right? Because the motorsports we've been running, you have been running for some times, and they've extended it by getting a planning permission, but people came to stay there and they sued the defendant accordingly. So Supreme Court reviewed the extent to which a grant of planning permission might change the character of a neighborhood and considered the approach to be adopted by the court when deciding whether to grant an injunction, to restrain a nuisance, or whether to award damages instead. The court held that mere fact that the activity, which is said to give rise to nuisance, has the benefit of planning permission is normally of no assistance to the defendant. Why? Lord Neuberger said, a planning authority has to consider the effect of a proposed development on occupiers of neighboring land, not just simply giving a permission. But that is merely one of the factors which has to be taken into account. The planning authority can be expected to balance various competing interests, which will often be multifarious in nature. There are four corners of issues that the local authority or planning authority should understand, because the locality is so important for us to consider whether it can affect society around or not. As best is can the overall public interest, bearing in mind relevant planning guidelines. Some of those factors, such as many political and economic considerations, which properly may play a part in the thinking of the members of the planning authority, would play no part in the assessment of whether a particular activity constitutes a nuisance, unless the law of nuisance to be changed fairly radically. Supreme Court said, Supreme Court is more sensitive now. Supreme Court is more lean towards the peace of the society. And all these things are effect of the problems that society has been facing after COVID, especially. You can see that everyone needs to have a proper livelihood. Okay, peace of mind is important. Stress has escalated within the society. These are some of the driving force why the courts are concerned about the interests in the neighborhood, people themselves, rather than your commercial interest in the business. All right. So reflecting, bring it back to the case of Sturgis and Bridgman, 1879, where the claimant has suffered personal discomfort and inconvenience. However, it is relevant. The classic quotation of Justice Desaiger in Sturgis and Bridgman, which I said just now, what would be a nuisance in Belgravia Square would not necessarily be so in Belmonte, which is an industrial area. Belgravia Square was in a residential area. So even though we have a distinct place, but nowadays, because of the development, because of the change of planning permission, things sometimes you fall into a very gray area, unclear area, whether this is industrial or this is residential. So in this kind of set of circumstances, the court got to be more sensitive to find out what could have been the best decision to be made if nuisance would have factually occurred. So therefore, in considering whether noise from a local factory causes a noise to a local residence, the courts will examine the nature of the locality as usual. And the nature of the locality may change over time from industrial to residential, and therefore courts must have regard to the locality as it is today. Change may happen naturally or may be due to deliberate development of the locality, as seen with the development of the London Docklands, which was classified as an urban development area. Urban development area. So, indeed, in Gillingham, when we look into 1993 earlier, before, Coventry was decided, and also you have other cases now, Justice Barclay held that planning permission to develop a disused naval dockyard, naval dockyard as a 24-hour commercial dock had changed the character, of the neighborhood. Local residents therefore could not complain about the serious disruption caused to them by its operation. But is it so today? Is it so today? Is it the same today? More recently, Supreme Court reviewed this again and analyzed the planning permission, which might change the character of the neighborhood where the defendant had long-standing planning permission to build a speedway racing stadium and later permission for a motocross track. Lawrence, who had moved into the area in 2006, alleged that there was a noise nuisance. Supreme Court overturned the decision of the Court of Appeal and then granted grant of planning and that the grant of planning permission had by itself changed the nature of the locality. That was held by the Court of Appeal. All right. And Supreme Court said it would be wrong in principle if through the grant of planning permission, a planning authority would be able to deprive a property owner of the right to object what would otherwise be a nuisance without providing her with a compensation. A decision has been made here. So that is so important, right, in our discussion here, planning permission part. And we must also develop our understanding to talk about Hunter and Canary Wharf and look into other type of nuisance and compare it with Fern against State Gallery. How different the decision is by the Supreme Court. If Hunter and Canary Wharf would come to court of law today, will the Supreme Court change their decision or not by saying that interference with the television reception may tantamount to nuisance? So that's a question mark that we need to ask ourselves. Can Hunter be overruled today? But of course, so far, no cases come into force based on the Hunter principle, based on Hunter's facts. Other than that, students can go into the normal discussion that you already had about the court's approach. For example, the sensitivity approach. You have Robinson and Kilward, and also this is about hot air, which affected the brown paper. Normally, the hot air won't affect any paper, but the brown paper was very sensitive paper. So the court said that, no, you can't. All right. Here also I've highlighted High Court decision of Fern, right, which is not necessary. You can also consider Hunter Canary Wharf with Supreme Court decision already. At this point of time, 2017, okay, we have had you see, one thing the students need to remember, a bit of a psychology in exemption, because sometimes we will always look into the law that we have read, and we always incline to follow the law. That is something that I always disagree with students, because critical thinking is required. We must always look into the law, evaluate the law to argue and to say that, no, look here, I think this is not agreeable. Even Hunter and Canary Wharf, when it was decided, I was not agreeable with Hunter and Canary Wharf. I don't agree. To me, there is an interference. Even not under nuisance, also at least under Human Rights Act. Article 1, Protocol 1. Okay, should have. Unfortunately, Hunter was decided in 1997. Whereas Human Rights Act was incorporated in 1998. You see, a bit too bad. So we cannot always accept Hunter as a good decision, even though it's a House of Lords, was a House of Lords decision. Same thing, right? When I didn't agree with that, Hunter was not appealed further, no more. Supreme Court already, House of Lords. But we must always look into the aspects of what do you think? What is your opinion? So when Tate was decided in Fern was decided in 2017, everybody will follow. Sorry, Fern was decided after 2017, right? But this exam question was in 2017, correct? So in 2018, 2019, we are still having the benefit of Tate's, Fern's decision of the High Court. 2020, 2021, we had the benefit of the decision of the Court of Appeal. I was still disagree. To me, I said, how people are going to go through their lifestyle when people from other building are observing you. There must be some solution. There must be some relief. And the decision doesn't seem to be helpful. Of course, Court of Appeal a bit more helpful in terms of allowing the claim under Human Rights Act, Protocol 1. But Human Rights Act might not be able to grant you an injunction. Okay, Human Rights Act possibly may allow you to provide you with damages. And the compensation amount is small under Human Rights Act. If you are successful in tort law, then your compensation is big, and that can include injunction, which is a very important remedy, especially when it comes to privacy in our life. So nuisance is about our life. Privacy law is about our life, human life. So I was thinking whether this case, that's a long-awaited appeal. That's why. So when I was reading this decision last year, right, it was a bit too late, so I didn't really go through this for the students' last year revision. But when I received this update, okay, this year, I realized that this is interesting when the Supreme Court made a decision. So in 2017, students who were answering the exam question, they don't have the Fern's benefit. What they had, Hunter's benefit. But in 2020, 2021, 2022, students who were attempting exam question, they had the benefit of looking at Court of Appeal decision. So what many students will do, oh, good, Court of Appeal, this is the decision. I'm going to analyze this. This is court's approach. Agreeable. But where is your challenge? Because if you would have challenged it, examiner would have read your challenge, because examiner already looking into the criticism made in the United Kingdom about this matter already. So they say, hey, this student is making a challenge, attempt to challenge. That's interesting on the part, even though there's no authority. Right? And today, there's nothing to challenge because Supreme Court already decided otherwise under Fern already. So when we look into a new decision where there is, even the old decision where there's no new authority yet, let's say, for example, issues of locality, planning permission, feel free to put some evaluation on your part. That will help you a lot in the examination. That's my advice. Okay, so that is what I am always show concern when it comes to examination for tort. Right. The next one is, of course, malice. How the courts approach when we have malice as an issue and the factors of discussion. So cases that we will consider normally will be Christie and Davy, together with Hollywood, Silver Fox Farm. Of course, the court say that malice is only a factor in Bradford Corporation and because it should not be a requirement. Nuisance, if it is a requirement, then very difficult to prove nuisance. Right? It's just a factor to consider. If there is a malice, easy to prove nuisance. If there is no malice, then nuisance can still be committed, but other aspects of the knowledge must be observed. Okay, on the part of the defendant. Then there will be good, I think the good decision made by the House of Lords, especially in the case of Bradford Corporation against no, this is not Bradford Corporation and Pickles. No. Bradford Corporation and Pickles. The defendant deliberate during his land. Yeah, correct. Okay. Now, the leading case, note caution should be adopted. However, towards comments in the leading case of Hunter Canary Wharf, a comment made by Lord Cook, okay, who suggested that malicious erection of a structure for the purpose of interfering with television reception should be actionable in nuisance. These comments were based on Lord Cook's minority belief. You see, in Hunter and Canary Wharf itself, there was a minority part of belief where his lordship said that deliberate, malicious erection should tantamount to nuisance. The only setback was the court did not recognize that particular interference as a category, part of the category. Noise, smell, or common category, but that reception was not recognized. So that is where the fatal to the case of, okay, Hunter. But if today Hunter to be decided, I think it might, Supreme Court might change their mindset. Okay, damage to property, yes, that is important. The court will only allow for a damage to property, not personal injury due to nuisance. But is it possible? See, people, let's say they create dust, a lot of dust, and it is actually going to the neighbor's land. And the neighbor is suffering from personal injury, like asthma. Why can't the neighbor sue under nuisance? Because you see, my opinion in this area is that when the court does not allow you to sue under nuisance, but rather you can resort through negligence. In negligence, you have a high responsibility by establishing a duty of care. Okay, fine. You owe a duty of care to a neighbor. Physical proximity, right? Physical proximity. Then, did you take sufficient precaution or not, right? So as not to allow this particular dust to go to the neighborhood. What if the claimant was not able to prove that? Was not able to prove that? That means the defendant did take sufficient precaution. Defendant did acknowledge that there can be interference with the neighbor. But what if the dust is toxic? The other day in the college, and there was some issues where students kept a pepper spray in the bag, and all of a sudden the pepper spray dropped, and then it was like going around. Okay, then it has been there's a ventilator where the aircon was there, and suddenly it went into the aircon ventilator for a moment. All students were suffering, and anyone enter the place will have immediate effect on that particular pepper spray smell. Not irritation to the eye, but the smell in itself. Because eye means when people spray onto your eye, then you have it. That in itself is considered to be so dangerous within that short amount, a small quantity. All right. And you take precaution, and frequency of this dust is not going to the neighborhood. That is fine. You can prove that there's no breach. But your neighbor is affected. Why can't nuisance allow personal injury in such circumstances, instead of negligence when it is so difficult to be proven? So my concern is that, right? Nuisance should be taught to allow such things. Same goes to Rylance and Fletcher. So we yet to see, because the decision of Hunter Canary Wharf also say that, okay, no. So 1997's decision state that you can't claim for personal injury under nuisance. But today we are sitting in the year of 2023. Are we going to what we call this paying a lip service to the same thing or not? All right. So then it creates some inconvenience with many people, especially those who are having this thin skull, such as pre-malignant situation where they are so easily affected by this kind of dust and noise or other smell, because many people are having these health issues, especially after COVID. All these things are general environmental argument on the societal impact today, whereas the law is not seen yet. Precedent is growing too slowly because there's no case that has been brought forward today, right? Challenging Hunter and Canary Wharf again on the issue of personal injury. Okay, so just to highlight, just to break our mind, okay, to look at it out of the box based on the law. That is expected also. Also, in terms of Shelfer and Coventry, in the aspect of what we call remedies of injunction, we are looking at how these things can be observed by the courts, whether Coventry made a good decision or not. This is also another aspect where you can actually make evaluation, on point of what would be the approach by the courts. Just a guideline, some areas for discussion purposes I've highlighted here in terms of the question highlighted by the examiner about approach taken by the courts in resolving conflict over competing users of land in private nuisance. Now, having said that, just give me a couple of seconds. I'm going to also taking the opportunity today to work with you, right, along the line to see what are the recent observation you can make, because tomorrow I'm going to focus on a bit on public bodies, and straight away I'm going into the article already. So I do not want to overlook what we should observe for this year besides the pre-exam update I've given to you earlier. Just give me a few minutes. Meanwhile, if you have any question, feel free to ask. All right. Got it. Let me share screen. So on pre-exam update 2024, just to confirm, do you have this material? Can I confirm that, everyone? I don't know. Is this a first revision? Should be a second revision already. I'm not sure. Oh, no, this is a first revision. The topics only flipped because I chose the first this batch. The other batch I'm not available, but the topics I'm doing. That's why you can see. I think negligence is later. Anyone? Anyone? Do you have this copy? Pre-exam update 2024. No, okay. Later I'll attach. Okay, let's run through first. So on pre-exam update 2024, okay, there is no new case, but University of London highlighted Alcock criteria again. Proximity in times of space based on the most recent question, 2024, sorry, case, 2024 case, UK Supreme Court, yeah, I remember seeing this case when I was doing a research on the latest cases, but University of London also, okay, brought upon this case. Taylor against Noah was considered. This is about the proximity in times and space. There are many issues and incidents where you can only see or hear later aftermath. Don't know how long the aftermath needs to be considered, which has created a lot of confusion, a lot of uncertainties from the case of Alcock. So Paul against Wolverhampton was the 3 conjoined cases pertaining to that. All right. I hope that you can read, and during your revision with this topic with your lecturer, you can discuss with them. No problem. Yeah. Liability of public bodies. Yes. This is the topic we are doing. And there was a decision in 2022, possibly a question this year. I don't deny the fact. Education and Social Work, HXA against Surrey County Council, is a decision that refrained from giving more generally applicable guidance. In 2 conjoined cases, it was held that the local authority could be said to have assumed a responsibility. Very interesting phrase. Duty of care, assume responsibility test used by the courts for the welfare of looked after children and thereby owed them a common law duty of care and negligence. This would always be a fact-specific decision, but included a wider range of situations than a care order. For example, undertaking a specific type of risk assessment. General guidance could not be given. Instead, a duty would be determined on a case-to-case basis, which shows that there is no new development. It's quite similar to the previous development where duty of care can be owed not for general task, but for a specific task of risk assessment, we call. And notably, this case used assumption of responsibility test, assuming the responsibility. All right. So something to note if you're doing public bodies as part of your exam. Breach of duty of care, there was another 2023 decision. Bolam says, warning risk, McCulloch against Forth Valley Health Board, where the question arose as to what standard of care should be applied to the determination of what constitute a reasonable alternative treatment for the purposes of informed consent. Always been, still a controversy in my opinion. It is still a controversial decision. That is the case of Montgomery. Although it's a challenging, it's a good decision for the patients, but there are always criticism about the decision, especially the medical fraternity, right? By having this informed consent. So here the Supreme Court held that this was a matter of professional skill and judgment, and therefore Bolam or professional test was the correct one to apply to this question. It is not expected the patient will be advised of all possible alternatives. Seemingly, Supreme Court is moving away from, or rather balancing or justifying Montgomery already, because the Supreme Court still having this mindset of really whether Montgomery should be a long-standing decision or not. Still concerned, right? So that is just to put you all in the loop of saying about how informed consent should be observed. Okay. Then we have employer's liability, a case of Beniatov against Credit Suisse, right? Court of Appeal strongly resisted a claimant's case that his employer's duty of care to him extended to indemnification for the economic loss he incurred due to criminal activities and he had committed to in pursuit of his duties. So these are about criminal activities that occurred, okay, right, on the part where the employer is liable, okay. Okay, so here I also leave it to the lecturer in charge to deal with it, okay, under pre-exam update, latest authority, together with vicarious liability also, trustee of Barry congregation, Jehovah's Witness. Again, we have another issue of vicarious liability, talking about people who are in the, right, religious organization. Another issue already, okay. So vicarious liability is an area of law still growing, expanding, and limitations are done, expansion were done, and the direction seems to be going off target. Direction seems to be going off target, especially after the decision in 2001 by the House of Lords, Lister and Hisley Hall. And further, especially the decision made by Lord Tolson in 2016, the Court of Appeal, Morrison's case. So we need to yet to see how Supreme Court going to manage this in future, right? So we already have one case here, Supreme Court. Then finally, the privacy, right? Privacy and misuse of private information, royalty, Duke of Sussex against MGN. I already shown you just now, earlier, yesterday. Okay, Prince Harry was successful in an extensive misuse of private information action against journalists who hacked his phone during 2006 to 2011. So when you talk about privacy law, yes, again, it is quite a popular area now. And this was in December 2023. I'm not sure. Looking at it, probably a problem question, as I mentioned earlier. But anyway, be prepared because your options are there. Options are there. Okay, and also another advice which I mentioned to our students. Okay, I saw Kathleen's remind me back on to attach this from Kathleen's message. Just a minute. Law of Tort. This is from KL Notes. Nuisance. Pre-exam update. No, pre-exam update. No, it's on the download. Sorry. Okay, you would have received it now. Tort Law, pre-exam update 2024. Right. And other than that, yeah. So student may be asking, what are the topics to prepare, right? What I would say is there is no such thing called distinct topics, but you must know the combination. If you're preparing for negligence, then you must know psychiatric illness and also negligent misstatement will be part and parcel of it. All right. If you're preparing for OLA, occupiers life, and also gender defenses. If you're preparing for OLA, right, you may have OLA and a bit of an intrusion of trespass to land issue, right? That is possible. Or maybe sometimes they can incorporate a bit of a trespass to the person issue. You see? Right. So, but the core topic you need to decide what you need, what you want, core topic, and you work with that along the line. And thirdly, of course, topics like nuisance, normally combined with violence and fracture, and you need to know a bit of negligence. Privacy law, we haven't really seen the trend yet, but of course, you can prepare by on its own standalone, shouldn't be a problem. Privacy law. Trespass to the person is not something that I can focus on due to, compulsory article. Due to compulsory article. So other than that, I think choices are there for you to prepare. Okay, after one compulsory, balance are 3 questions. And the pattern of the exam questions are almost similar. Not to worry. So you can have a choice already what topics you want to target on. How the questions are worded, that's something that you need to experience. Okay. So having said that, let me quick run through the material to see anything that I have left out for you for today. Starting from the first page, we have done, just to confirm what we have done so far and anywhere or any parts that I've missed. 2024, 23, I've done this part. Let me browse too quickly. Okay, too fast. Oh, no, not this one. This is the other set. Not this set. This is not yours. Hmm. And moving backwards, 2022 done just now. Okay, with some sample approach. 2022 resident in Greenbank. There's a case here in 2004. It was held excessive dust. Please take note of this case when you read it. This is something for illustration purposes about dust. Okay, network rail infrastructure against Morris. Okay, it gives rise to a private nuisance. A different question, you may have different specific cases. So to highlight, Tetley and Chitty, Coventry done already. 2021, Hunter Canary Wharf, Robinson, Adam and Ursel, public nuisance, State Lyle Industries. Okay. Christie and Davies, I've highlighted those cases already. There's another case, 2008. Dyson, Lord Justice Dyson, Corby Group litigation claimants against Corby Borough Council. Only public nuisance, a tort seeking to protect against unlawful acts or omissions which endanger the life, safety, health, property, or comfort of the public will permit damages for personal injury to be recovered. So which means in public nuisance, there is a possibility for you to claim for public personal injury, just to highlight that to you. Okay. Not for private nuisance. Corby Group litigation against Corby Borough Council, 2008. And 2021, problem question, 2020, this question I didn't do because during COVID. 2019, problem question, very brief info I gave. 2019 also. Problem question, cases of difference, no, similar. All these cases are quite standard. Quite standard. 2018. Okay, I have added some cases here. This is a bit more of a approach that I've given to students. And you can see there's a case called SCM against Vital. This doesn't necessarily isolated escape. Yeah, isolated escape issue. Nuisance must be a continuous, not isolated. So, but there are cases seem to suggest that there can be isolated event, tantamount to nuisance also. Crown River cruises about 15 minutes fireworks, tantamount to nuisance. Right. Other than that, all other cases are generally say the same. No different. Evaluate. Okay. With that, we are actually done with nuisance. Feel free to read when you are free at home, and maybe based on the guideline, you can prepare an answer and send to me. Okay, you can do that. I'm still of assistance to mark your papers, right, and give comments on that. So if there is 1 more minute, feel free to ask if you have anything, general question on tort or specific question on nuisance today. Right, I believe everything is fine with you. That's the case. It's already 5:30. We call it off for the day. Thank you very much. I'll see you tomorrow. Take care. Thank you. Well, good day to you.